As mentioned, Your Honor,
this isn't exactly my testimony, but thank you very much for giving me this opportunity in a court of law in my country. I consider it a rare privilege and an honor to do this. Thank you to Mr. Prosecutor and military personnel who are here and all the defendants and supporters. Your Honor, I do not have the benefit of comparing notes with the other people making closing arguments. I apologize for my redundancy, but there are some glaring deficiencies in the case as presented by the prosecution. They're numbered. 1, it should be eminently clear to the court that the defendants, to an individual, did not have any criminal intent, either general for trespassing or specific for disorderly conduct. As for any intent that can be inferred by the facts of 25 October, Chief Master Sergeant Ramsey testified that the base was at no time threatened by the presence of the defendants. Further, neither the base nor the police were in any apparent rush to remove the defendants, confirming the idea that the defendants were not causing alarm, disturbance, or annoyance. The prosecution presented no evidence that there was any annoyed public. 2, additionally, the legislature could have included blocking traffic within the definition of disorderly conduct, but it chose not to. So the defendant should not be found guilty based on blocking any traffic if in fact the court believes they blocked traffic. 3, it has been postulated that the defendants were trying to get media attention, which is true. But the defendants pursued media attention through press releases, press conferences, the internet, and other constitutionally protected means. Getting media attention is not a crime, and specifically is not so under disorderly conduct or trespassing. 4, Chief Master Sergeant Ramsey and Colonel Evans, official representatives of the base, and the ones who are responsible for maintenance and security of the base property, while testifying, gave different descriptions of the base property. On the Town Line Road side of the base, their description differed by about 750 feet, while their testimony about the main gate fortunately did not differ so wildly, it varied significantly. The chief, within his own testimony, testified the right-of-way was 25 feet from the edge of the road, and then pointed out the edge of the right-of-way on the video as a place that was about 8 feet from the edge of the road. In addition, they testified that the base commander took affirmative action to direct his personnel not to mark even where they think the edge of the public right-of-way might be. The arresting officers taken collectively describe the edge of the right-of-way everywhere from just outside the gate to the edge of the road. And the prosecutor, instead of clarifying where the public right-of-way ends and the private property begins, resorted to claiming the boundary was where a reasonable person would reasonably believe it was, a kind of shocking standard for defining property boundaries. 5, and to add to the confusion, even if the defendants or the court knew where the boundary was, the arresting officers in most cases had, at best, a very vague idea about where the person they arrested was at the time of the arrest. Videos showed people in a variety of places, but did not add significant evidence of who was where relative to the right-of-way when they were arrested. 6, there is no doubt that all the defendants were verbally told that, in the opinion of the arresting officer, they were violating a law if they didn't move. Testimony of the arresting officers who were standing right next to the citizens petitioning for redress gave every conflicting testimony about any warning given. Some said they didn't hear any warning at all, and some said they heard a general advisory. If the arresting officers, presumably highly attuned to the details of a legal arrest and to the actions of their commanders, are in doubt about any warning of arrest, it sheds serious doubt as to whether the defendants or which defendants were told they were violating a law and subject to arrest. 7. The case was made repeatedly, maybe ad infinitum, that the operations from within this base are unjust, wrong, immoral, even inhuman, and constitute war crimes, crimes against humanity, and perhaps crimes against peace. This case could have been much clearer for the court if the prosecution had not denied us the evidence on this very matter we asked for in discovery. Additionally, the memorandum in support of the in limine motion describes the court cases and laws supporting the facts of crimes and why international law applies to this case in greater detail than was presented verbally in court. 8. The point was made that the mechanism which keeps our republic a nation of laws is broken. The administrative branch of the government, from the president down to Hancock Airfield, is violating the law and tries to stifle petitions for redress. Meanwhile, the judiciary branch, from the Supreme Court down to town courts, like this court, have abdicated their responsibility to rein in the administrative branch, bringing it back within the law. As law-abiding citizens, we have been drafted or called on to take these violations of the law to both the administration and to the courts. The base, as part of the administrative branch, made no effort over the 2 hours to discover if we were petitioning of government for redress, let alone on what basis we might be petitioning. Worse than that, the base gave orders to its gate personnel that they were not allowed to so much as receive anything from the citizens. Now we present this court the opportunity to take its small piece of the judiciary responsibility to restore the balance of powers, to restore a government by laws. 9. Furthermore, there was testimony that the base is the one appropriate and constitutionally protected place for petitioning the government for redress of war crimes. 10. The evidence presented showed that, unlike domestic law, in international law, educated authorities, publicists, are taken as the same level of legal authority as case law. This puts great importance on the statements by Ramsey Clark, corroborated by Francis Boyle, that international law should be applied in all town courts and that citizens have a so-called Nuremberg privilege. 11. We are not asking for nullification as suggested in this court's earlier ruling. We're asking for enforcement of the law. We have again presented much evidence establishing that there are war crimes, crimes against peace, and crimes against humanity being committed from Hancock Air Base. In addition, we have presented more citations confirming that international law is part of the law this court should base judgments on, and cites demonstrating that we have a privilege to obstruct the commission of these war crimes, as well as to petition our government for redress of those crimes. 12. The judge in my trial in Quantico, Virginia, put the problem in words when she said, quote, "I find you guilty of aggravated blocking the traffic, and as for those lofty ideas of international law, they have no place in my court," unquote. I sat there, and in my mind, I could hear a judge down south in 1940 saying, "I will find you guilty of violating the Jim Crow laws, and as for those lofty ideas like lynching, they have no place in my court." We offer this court the opportunity to fulfill its responsibility and find us innocent through international law, helping to establish the rule of law and reestablish the balance of powers. 13. Citations were presented that show that the Nuremberg principles while never ratified by the U.S., are indeed accepted by the world as an indisputable description of the norms of customary international law and are therefore part U.S. law. 14, and the last one, when people talk about Nazi Germany, they often talk about the so-called good German, a name used for those people who could not see the Holocaust even as it happened, and they smell the ashes wafting across their towns, that's mine, before their eyes, who stood quietly as their government shifted from a democratic government to a dictatorship, from a progressive liberal country to a demonic empire. One day, people may talk about the good Americans who stood by when the balance of power remained broken and found various excuses for not using the portion of power they had to fix it. For all these reasons, the court must find the defendants innocent. This is my statement. Although I very much respect how you conduct your court, and I do believe you are a fair man, I regret very much your decision to disallow a Skyped testimony for our expert witness, Dr. Francis A. Boyle. In our case, my case really, is not necessarily just about the charges of trespass, never fully proven by the prosecution, nor clearly demarked by the witnesses who gave testimony, or disorderly conduct. Every prosecution witness speaking to our polite demeanor and cooperation. To disallow an expert, a brilliant legal mind, to speak to our exact claims for intent, breaking of international law, and attempts to stop war crimes from being carried out in our own backyard is our right and responsibility as U.S. citizens. The result of the insistence of a memorandum from Dr. Boyle instead of a live testimony thwarts the interpretation, nay, the very evolution of the law as it is discussed and given life in the spoken, open, and free dialogue. As a result, our trial, regretfully, is not a fair one.
Thank you. Mr. Rick.